Hello, and welcome to Your Estate Matters with your hosts, my colleague Greg Brenand and myself, Nicole Garten of Heritage Trust.
Your Estate Matters is a podcast dedicated to everything estates, including building and preserving your legacy.
If it's estate related, we'll be talking about it. We're having the conversations today that will help Canadians protect their families, their assets, and their legacies tomorrow. Okay, so today on Your Estate Matters, we're going to talk about wild and wonderful and interesting scenarios that we've encountered over the years as estate administrators. So I'm here with my colleague, Greg Brenand, who is a very experienced estate administrator who has 20 years of experience working not just for Heritage Trust, but for another public organization. And we're going to ask Greg some of the interesting scenarios he's encountered. So the first one I wanted to ask you about, Greg, is I understand you've had to actually exhume bodies. Tell us about that.
Well, that's true. It's from time to time, you will find an estate that it was either probably an intestacy where somebody is challenging a will, that they may have had a child somewhere else at some time in their life. But the person has now been buried 5 or 6 or 10 years and the estate's not settled for whatever reason. And somebody comes out of the woodwork and says, I'm their son. Well, what can you do? So you have to test DNA. So if there's no male or close female relatives, it's very hard to determine. You could say they're related, but are the issue of the deceased. So what you have to do is you then have to make an application to exhume a body. And that would be, you can't just go and do it on your own. It's a very formal process that you go through, and you have to inform the funeral home, and different cemeteries will also have different regulations about the exhuming the body. I think you have to have a funeral director present, if I recall. The last one I remember was about $10,000 of cost to get everybody there to remove the casket, to take what was needed for DNA samples. And then there's often regulations with the cemetery that you can't put the same casket back in because the caskets, depending on how long it's been in, could be quite degraded. And so you then have to buy a new casket and have a funeral director remove the remains and place them in a new casket and place it back in the ground and then test the DNA.
So I understand that there was a piece of a shin bone extracted?
I had an estate where a fellow had been deceased in his residence for a very long time, and we believed him not to have a will. So he was basically, unfortunately, in a very poor state when found. And we didn't believe that we could get DNA because my goal is always to take DNA either in the funeral home or potentially at the hospital if there's been samples taken, if they've died at hospital and they have blood samples or whatever, they'll still have them around, some pathology stuff, and you can get DNA from that. So ideally it's done in the hospital, but if not, you need to probably involve a funeral home. And in this case, we still had the body and we thought it's a substantial estate, so somebody could come out of the woodwork, and it does help prove them. So you can contact one of the many companies that test DNA to get them to send a kit. But in this case, we contacted the DNA company and they said, well, judging by what we've heard about the state of the body, we don't think we can get DNA from the cheek, buccal swab, hair. They would need a bone fragment. So we had a pathologist who was an ex-RCMP officer that worked around the corner go and remove a section of shin bone of the deceased, and it had to be sent down to Texas to a specialty firm that did multiplication of DNA. There's a special process, cost about $2,000 to have it on our file in case anybody walked out of the woodwork.
So are there, if I understand, there's best practices if there's an intestacy, meaning someone didn't have a will and the estate is over a certain threshold, that it's a best practice to actually obtain a DNA sample.
Absolutely, right? Because if it's just on site, because it is like a piece of evidence, the body has to be identified, the person taking it has to take notes as to what was done. Then, it's controlled like evidence, goes to the DNA company, they do it. And they can test people all over the world. So if Sally in Munich says, I'm a daughter, there'll be a local DNA place that can do the test and send them the, I guess, the monograph of all the genes, and it can be matched or not matched, and just say, "Sorry, you're not," even though your mother always said he was the father. This is not your dad. So it's that cost typically just a straight up sample from the deceased, 300 to 500 to have it put in foil and to get the report. So the report and the DNA company always has it.
And so that's one of the benefits of having a professional executor is knowing those best practices.
Well, seeing what might be coming down for a challenge to the estate, and relatively speaking, for a couple of $1 million estate, that's less than 1 hour of a lawyer calling you, writing a letter saying, "Hey, we have an intestate heir."
So someone's passed away, you've dealt with the remains, and now we are dealing with funeral instructions and arrangements. What are some of the unusual and interesting scenarios you've encountered?
Well, I had a gentleman that, again, was not found for quite some period of time. He wanted to be buried back in his home European country, um, which is fine because the body was preserved enough you could do it. So if the body's not preserved, you can't ship a body that's in bad shape. You would have to cremate it and make other arrangements. And what is involved is normally the funeral home gets involved, but you have to get the consul involved because when you're going to ship a body back over to, say, Europe, the consul will show up at the airport. There's a special room they go into. They have to open it, look at the passport, look at the person in whatever state they are. I guess the consul's earning their money that day. They have to sign some documents to accompany the body, and they have to put a consular seal on the casket. So it usually involves a funeral home here, a receiving funeral home in the other location, and those documents have to travel with it because they're burying a person they don't know, right? Another one is I had a fellow that used to be a train engineer, and he died here in BC where he was resident for many years, and he wanted to be buried back in the prairies, and the appropriate railroad would do it. So we shipped him on the railroad in the casket. He got a nicer car. Usually, there's a certain car they'll stick caskets in, to be accompanied back to his home province and to his hometown to be buried with his family.
Lovely. So we had one recently where the deceased had a special request of a very valuable casket. Do you want to talk about that one?
Deceased, as long as it's put in the will, you can try and accommodate it. And if it's got specialty railing, specialty interior, other strange things you'll see with that is also locations. They want to be facing north, or their feet want to be west or east, or near a tree. So that cemetery, that's one side, and the casket. So you'll have to find a funeral home that's able to source that type of materials. So locally, these would be cemeteries that you would see like Ocean View or some of the more expensive ones, because the casket, typical casket will run $6,000 to $8,000. You get into the more expensive custom caskets, specialty items, you're going to run 40, 50,000 plus.
So I recall it was a platinum casket and it was about $50,000.
Yeah, and it's probably more today because there'd be very few sold, and it would be a specialty item. And a lot of people making those types of arrangement maybe will even do them in advance. I once, many years ago, had a person that was a published interior design artist from Canada, published in America, educated all over the world, and she died here in Vancouver, but she was from a prairie city, and we were going to send her remains back to be buried. It was a prominent family from that city, and we called a memorial office across from where we knew the family was buried, and we said, well, we wanted to create a stone memorial. It's one of these old families that has really big stones, and they said, no, she ordered it years ago. We already have it here, and it was beautifully done because she's a designer, and it said it already had her daughter's name on it, who was living as well. But I just said, what a piece of luck. Yes.
So we've had ones where they want reggae music and an open bar. What are some other interesting funeral instructions you've
Uh,
had?
People to go on last motorcycle rides with the group, sort of 2 or 3 towns. And these are more instructions that people should actually put with their will, because the executor really can't say what a celebration of life should be. I mean, obviously, you can release ashes or something to a family member, and they can decide what to do. But if they want the estate to pay, there should be some indication or some financial amount that's set aside. We've seen as much as $100,000 for various 4-day parties, uh, these types of things. So it really depends on how the deceased lived. But if you died intestate, usually there would be no money put aside for that type of party because there's no instruction.
Right. And what about families in conflict? We had an estate where there was a fist fight at a funeral. What are some conflictual scenarios you've seen?
I had one where a fellow deceased, his adult son with special needs, was living with him. He had been divorced for 30 years. So that probably showed for the dad to get full custody 30, 40 years ago, what the situation was. And the son, who was despondent, unfortunately took his own life about 4 or 5 days later. So we were going well, we ended up to do the two estates. However, now the son's bloodline next of kin is his mother. His mother would not allow a joint celebration of life or joint things, even though they were basically estranged for a couple of decades or more. And that was very sad to see that these two items occurred.
But a way to avoid that is to do planning in advance.
Absolutely. If even a basic will that gave authority to somebody else, or to prearrange your funeral and decide what type of arrangements you want to have. If you don't have a big estate, you can still prearrange your funeral.
And what about animals? We've had people that want to be buried with the ashes of their pets. And what have you seen?
I've seen scattered with the pets, and that just brings up another issue that falls into estates all the time, is the family follows sort of cremation as the default, and the last to die has a mantle with 6 individuals on it and maybe some pets. Before, you couldn't deal with. The law was recently changed here in BC, so now you would normally try and inter them all together because you didn't have authority over the other individuals. You didn't administer their estates. But people should think about that when they write in their will. I want to be cremated, and who should your ashes be released to? Do you want them scattered? Do you want them in a columbarium? Do you want them given to your sister? Or some people, of course, always want them segmented. 8 people get 8 segments.
So we've certainly had estates where we've had to divvy up ashes.
Yeah, it's not uncommon. Mhm.
And do you want to leave us with a final interesting story or scenario that you've seen?
Well, um, certainly, there was a person that deceased that had 5 corporations. We didn't touch any of them. Uh, they unfortunately died in an unexpected way, but they had a large life insurance policy that they paid very few premiums on, and we were surprised the insurance company paid off. It was in the millions, and that accompanied 26 lawsuits against the estate. And and so we had to sort ourselves through 26 different lawsuits, and we came out on top with a little leftover of settling all the lawsuits, and that was paid to uh, beneficiaries of his children with many women.
So people that live complicated lives leave complicated estates.
They do, and there was really no planning, although of complicated affairs, and people really need to put their mind to it. What would you say? How often should they update their document?
So the rule of thumb is first of all, get a will. That's a will. That's a win because half of Canadians approximately have done no planning. So if you even have one, you're ahead of the game. But the idea is get a basic plan in place, so a will, but you should also think about incapacity. So a power of attorney if you're alive but incapable for finances. In British Columbia, the healthcare document is called a representation agreement.
Yes.
So you should have a basic will, a basic power of attorney, a basic representation agreement for healthcare. And then every 5 years, approximately, and or if something significant changes with your assets or your family, you should take a look at it. So the idea is it's not very expensive or onerous to do planning. But if someone becomes incapable or passes away without planning or with a messy estate, it can take many years and cost a lot of money and increase conflict for their family members.
Yeah, so when you see it, whatever the cost of the preparation of the documents, when the documents are actually needed, they save money in the long run because just hours of lawyers' fees are saved when there's not been documents put in place.
Right. So I think we'll leave our listeners with a small amount of planning can save your family an enormous amount of time, money, and potential heartache. So it's a good time to get started today. This podcast is for informational purposes only and should not be considered individual legal, financial, or tax advice. Make sure to consult the advisor of your choice to advise you on your own circumstances. Thank you for joining us for this episode of Your Estate Matters. If you like this podcast, make sure to follow it on your podcast platform of choice.
Whether you are planning your own estate or you're acting as executor for somebody else's, Heritage Trust can help. Partner with Heritage Trust to protect your family, your assets, and your legacy.
If you would like more information about Heritage Trust, please visit our website at heritagetrustcompany.ca.
This podcast is produced by Podfather Creative.